Good morning. This is Rajeshkumar. Today we are going to analyze one problem question in Property Estoppel. At the offset, I am going to start with an introduction about the Property Estoppel, and then we are going to solve a very interesting problem question in Property Estoppel with the help of case laws. The question is about G and M live together. G purchased a house, but M furnished and redecorated the house. M paid the household bills and son's school fees. At one point of time, both split up, and G insisted no entitlement for M. We have to advise M whether M will get a share of the property or entitled only to the monetary compensation or a combination of both, or M may not get a beneficial interest or life interest in the house. In other words, none at all. Let's analyze. Disclaimer. Please go through the disclaimer. The video content has been made available for informational and educational purpose only. Proprietary estoppel. What is proprietary estoppel? The essence is that where the defendant has made a promise or given an assurance that the claimant will acquire an interest in specified property, and the claimant has relied on his promise or assurance to the determined. The claimant has a mere equity entitling a relief, which might involve the claimant acquiring an interest in the land or other assets. It's nothing but someone has given an assurance or promise, the other party believed on it. This is more likely like a constructive trust. What's the difference between the constructive trust and the proprietary estoppel? There is an overlap within the constructive trust, but note the main difference between the two, where the proprietary estoppel is based on representations, whereas the constructive trust relies upon bargains or the common intention. The proprietary estoppel is a means by which a person may acquire a proprietary interest in another's land. It describes a situation where a person is prevented, or as we say, stopped from denying the truth of the particular factual positions or legal status. In order to prove the proprietary estoppel, there are four requirements to be filled or fulfilled. The first one is a representation. There must be a representation or assurance. The representation can be made by silence or inaction. For example, in Turner versus Major case, someone has worked on the relative farm for 29 years without any payment. The farmer died and he has not made any express representation. House of Lord held that it was sufficient that the claimant reasonably understood that he had received the assurances from the farmer that he intended the claimant to inherit the farm. The second requirement is reliance. Must have been a reasonable in all the circumstances. Not necessary to prove that the defendant knew of or the foresaw the claimant's particular acts of reliance. It may have been made by somebody else, but the defendant must be aware that it was made. The third requirement is determinant. A claimant must have suffered the determinant as a result of reliance on the defendant's representation or assurance. The determinant need to be have been sufficiently substantial to justify the intervention of equity, but need not involve any expenditure. The fourth requirement is unconscionability. I will explain using the case law like Kobe versus Yeoman. A claimant and the defendant, both of them entered into an oral agreement for the sale of the land. Despite the claimant's detrimental reliance on defendant's assurance, the property would be sold to the claimant. It was held that a defendant's conduct in reneging on the agreement, while the dishonorable and was not unconscionable, because the claimant had taken the risk that a formal agreement would not be made. Let's move on to the problem question. In 2001, George met Martha when she was studying at university in Oxford. Martha was working as a personal assistant to the managing director of a pharmaceutical company. After graduating in 2002, George he set up a business as a freelancer set designer for TV and theatrical productions. So, after a year later, George purchased a house in London for them to live in together, using his savings for the deposit and obtaining the balance of the purchase price by granting a mortgage to the angry bank. Martha, from her side, Martha gave up her rented accommodation to move in with George. However, a title of the house was registered in George's names only. At that time, Martha suggested that registration should be in their joint names. But George persuaded her not to press the point. He told her, "Come on, Martha, you don't need to be concerned about the legal niceties. You know how you can trust me." George, who was indebted with work, paid the mortgage installments as well. So, Martha, she just gave up her rented accommodation. That's it. But George, he's the one who bought the property and he paid the mortgage installments as well and he paid the initial amount. But from Martha's perspective, Martha's part is Martha used a small inheritance from an aunt to furnish and redecorate the house. George and Martha decided not to marry. In 2006, Nick, their son, was born. In 2010, George started to experience difficulties in finding the design work, although he was earning enough to continue meeting the mortgage repayments. They decided it would make sense for Martha to return to work part time as a personal assistant to her old boss. Since then, Martha has paid all the household bills and the Nick's her son's school fees. Earlier this year, George and Martha split up. George insisted that he is going to sell the house and is adamant that Martha has no entitlement in respect of the family home. We have to advise Martha. In summary, George and Martha have been in the long term commitment relationship, living together in a house that George purchased using his own savings and mortgage. Despite Martha's suggestion that the house be registered in both their names, George persuaded her not to insist on this, telling her that she could trust him. Let's analyze the question and we'll start answering. Under Gissing versus Gissing and the Lloyds Bank versus Rosette case, Martha may be able to establish a constructive trust if she can prove a common intention with the George that she was to have an interest in the property and she acted to her detriment in reliance on that common intention. At the same time, George's reassuring statement to Martha about not needing to be concerned about the legal niceties and that you know how you can trust me could be interpreted as an express common intention as per the Rosette case. Martha's actions, such as giving up her rented accommodation and using her inheritance to furnish and redecorate the house, may be sufficient to demonstrate the detrimental reliance. The principles established in cases like Gillette versus Holt and Turner versus Major suggest that Martha may have a viable proprietary estoppel claim. Martha can argue that George's assurance about her not needing to be concerned with legal formalities created by reasonable expectation that she would have an interest in the property. Martha's actions, such as moving in, contributing the household, and paying the bills and the son's school fees, may be considered as determined reliance on the George's representation. If Martha successfully establishes a constructive trust or the proprietary estoppel. The court will need to determine the size of her equitable interest in the property. Cases like Stack versus Down and Jones versus Carnot provide a guidance on how the court may approach this, considering the parties' intention and the overall course of their dealings. Martha's indirect contributions, such as paying the household bills and school fees, may be taken into account in quantifying her interest, as per the principles in Stack and Jones versus Carnot case. First one is representation. George clearly made a representation to Martha that she need to be concerned about the legal ownership of the house, telling her you don't need to be concerned about legal necessities. You know how you can trust me. This implies an assurance or expectation that Martha would have an interest in the property, even though it was registered solely in George's name. Hence, the Marthas gave up her rented accommodation to move in with George and live in the house. She used her small inheritance to furnish and redecorate the house. Since 2010, Martha has paid all the household bills and Nick's school fees, while George has experienced difficulty finding the design work. These actions and contributions by Martha demonstrate a detrimental reliance on George's assurances about her interest in the family home. Martha relied on the George assurance by giving up her rented accommodation and moving in with George to live in the house. This reliance is akin to the case of Grant versus Edwards and Combs versus Smith, where the claimants were found to have determinedly relied on the representation made to them. Martha used her small inheritance to furnish and redecorate the house, which can be considered as a determined or financial contribution to the property. Additionally, Martha gave up her own rented accommodation to move in with George, which can be seen as a personal determinant. In Southwell versus Blackburn case, the court have interpreted the determinant broadly, encompassing giving up a secure living situation. Martha's giving up her rented accommodation fits this criterion. Unconscionability. George's insistence on selling the house and denying Martha any entitlement, despite her significant contribution and reliance on his assurance, appears to be a unconscionable behavior. The case of Azia versus Turner and Gillard versus Holt demonstrated that the court can find such conduct unconscionable and grant relief to the claimant. Let's see a few more cases. A Taylor Fashions Limited versus Liverpool Victoria Trustees Co. Limited. In this case, even though George may have been ignorant of the true legal position at the time, it would still be unconscionable for him to insist on his strict legal rights given the circumstances. Matthew versus Matthew case, may still, based on that case, Martha may still succeed in her proprietary estoppel claim, even without George making an explicit promise or representation, as long as the court find it would be unconscionable for him to deny her interest in the property. Based on the Grizzly versus Cook case, there is a rebuttable presumption that Martha acted in reliance on George's assurance and the onus is on the judge to prove otherwise. In Rebasham and Whaling versus Jones case, the doctrine of proprietary estoppel can apply even though Martha did not have an existing interest in the property, as George encouraged her to act to her own detriment on the understanding that she had a share in the home. Based on the Gillette versus Holt and Jennings versus Rice case, the court will take a holistic approach. The judge the facts as a whole to determine whether Martha has an estoppel equity and how it should be satisfied. The key factor is whether it would be unconscionable for George to deny Martha's interest. The case of Dilwyn and the Fassier versus Turner case and Turner versus Major suggests that where the claimant's expectations are clear and the detriment incurred is significant, the court may award a remedy of transferring the fee simple, the full ownership of the property to the claimant. However, as per the modern approach outlined in Jennings versus Rice case, the court must ensure the proportionality between the claimant's expectation and the determined suffered. The court has a discretion to award the minimum equity to do the justice based on the specific circumstances of the case. In this case, given the clear representation made by George, Martha's substantial reliance on determined, and the fact that the property was intended for the joint occupation, a strong argument can be made that Martha should be awarded at least a beneficial interest in the property, potentially even a transfer of the full ownership. The court may also consider other remedies such as life tenancy or a financial award if a full transfer of ownership is deemed disproportionate. The court will likely balance a Martha's reasonable expectation with the overall circumstances to determine the appropriate remedy. Regarding the impact on the third parties, as per the sections 116 of the Land Registration Act 2002, Martha's uncrystallized estoppel equity would be capable of binding a successor entitled to the property, provided it is properly protected through registration or by the virtue of the actual occupation. In Gillette versus Hall case, the court rejected the need for the double assurance, finding it sufficient that defendant behaved unconscionably in withdrawing a promise relied upon by the claimant. In Axley versus Gold's case, the proprietary estoppel can still operate even when an agreement relating to the land is void for lack of formality. Whereas in the Holman versus House case, where the assurances are made that allow the claimant to occupy a property, and the claimant relies on these to their detriment, and the property estoppel will be satisfied. Given the strong facts supporting the elements of the proprietary estoppel and the President's allowing for its application, even without the strict legal title, Martha has a compelling case. The court is likely to find it unconscionable for the judge to now deny Martha any interest in the family home after she has significantly relied on his assurances to her determined. If the court is satisfied that the requirement of the proprietary estoppel are met, it has a broad discretion in fashioning an appropriate remedy. Based on the precedents which we have seen before, some options include a granting a Martha a beneficial interest in the property, a potentially a 50% share to reflect her substantial contributions, ordering that the property cannot be sold without Martha's consent, as in Home versus House case, awarding Martha a compensation such as a lump sum payment to satisfy the equity. Potential remedy will be the court will aim to provide a remedy that is proportionate to the determined suffered by Martha rather than necessarily transferring the full legal title. However, given the extensive nature of Martha's reliance and contributions, a significant proprietary interest in the family home is likely the most appropriate remedy. Monetary compensation. At the second stage of the analysis, based on the precedents, the court has a wide discretion in this regard, ranging from awarding Martha a share of the property, as in the Fairey versus Turner case, to granting her a monetary compensation, as in Campbell versus Griffin case, or a combination of both, as in Gillette versus Holt. This is a very important slide. The most suitable remedy for the Martha would be to grant her a beneficial interest in the property, either as a joint owner or through a consecutive trust. This would be in line with the principle of fulfilling the promise or expectations that George had created and encouraged in Martha, and would prevent the unconscionable outcome of Martha being left with no interest in the family home she had significantly contributed to. In Sugit versus Sugit case, the Court of Appeal upheld a significant remedy. The entire farmland and the house worth over the 3 million pounds, despite the limited work the claimant had done, as the value of the property reflected the unconditional assurances made. Similarly, in this case, the value of the family home should be considered in light of George's assurance to Martha, and the court may award Martha a proportionate interest in the property to satisfy the equity created by proprietary estoppel. The key issue here is the nature and the extent of the interest that Martha may be able to claim. The court have generally been reluctant to grant a full beneficial interest in the property and have instead favored the award of a financial remedy. This is a very interesting case. In cases such as Lloyd's Bank versus Rosette and Oxley versus Hisark, the court have held that the claimant must demonstrate a direct financial contribution to the purchase price of the property in order to establish a beneficial interest. But Martha hasn't financially contributed at the time of the purchase. So in this case, Martha did not contribute to the purchase price as a deposit and the mortgage were provided by George alone. Similarly, in cases such as Jennings vs. Rice and Gillette vs. Hall, the court have emphasized that the remedy under the proprietary estoppel should be proportionate to the detriment suffered by the claimant. So, in our case, while Martha has suffered a detriment by moving in and contributing to the upkeep of the property, the court may consider a financial remedy such as lump sum payment or a right to occupy the property for a certain period of time to be more appropriate than granting her a full beneficial interest. Now we come to the last slide that we are going to conclude. The court has a broad discretion in determining the appropriate remedy in proprietary estoppel cases. As seen in the case such as Mayer versus Coley and the Gary versus Rankin, the court may choose to exercise its discretion to award a financial remedy or even no remedy at all. The court would be reluctant to grant a Martha a full beneficial interest in the property. Instead, the court may exercise its discretion to award her a financial remedy, such as a lump sum payment or right to occupy the property for a certain period of time to reflect the detriment she has suffered. Thank you.